in the matter of Secretary of State for Work and Pensions versus Gubeladze.
Lord Sales will explain the decision of the court.
This case concerns the free movement rights of a Latvian national under EU law in the period after the accession of Latvia to the European Union with effect in 2004. By a treaty signed at Athens in 2003, 10 accession states became member states of the EU in May 2004. The Act of Accession, annexed to the Athens Treaty, permitted the existing member states to apply national measures regulating access to their labour markets by nationals of the 8 most populous accession states, known as the A8 states, which included Latvia. The existing member states were entitled to apply such measures until the end of a 7-year period following the date of accession, that is to say, until 2009. An existing member state was also permitted to maintain such measures in place at the end of that period for a further 2 years if there were serious disturbances of its labour market. The Act of Accession was given effect in the domestic law of the United Kingdom by regulations made in 2004. The 2004 regulations established a worker registration scheme which obliged any national of an A8 state to register before starting employment and before taking up any new employment. Each registration incurred a fee of £90 and the obligation to register continued until the worker had worked for 12 months. In 2009, the government asked a panel of experts, the Migration Advisory Committee, or MAC, to advise it in relation to the continuation of the registration scheme. In the light of the MAC's advice, the government decided to extend the registration scheme for nationals of the A8 states for a further 2 years. The question in this case is whether the respondent to the appeal was Gubeladze, a Latvian national who lives in the United Kingdom, is entitled to receive state pension credit. The respondent came to the United Kingdom in 2008 and worked for various employers between September 2009 and November 2012. She was issued with a registration certificate under the registration scheme in August 2010. Her employment before that date was not covered by the certificate. On the 24th of October 2012, the respondent made a claim for state pension credit. The basis of her claim was that she had a right of residence in the United Kingdom under Regulation 5.2 of the relevant national regulations made in 2006, which implemented Article 17.1a of what is known as the EU's Citizens Directive. She claimed that she fell within the scope of these provisions as a person who had retired, having pursued activities as a worker for at least a year in the United Kingdom, and having resided continuously here for 3 years. The Secretary of State rejected her claim on the ground that the requirement of 3 years continuous residence meant 3 years continuous residence which was legal in the requisite technical sense, as that term is used in certain places in the Citizens Directive, even though it does not appear in the text of Article 17 of that directive. According to the Secretary of State, this meant that rights under Article 17 could only arise where a worker had acquired a right of residence under the Citizens Directive itself. Since the respondent's asserted right of residence during the relevant period was as a worker, but she had not been registered under the registration scheme for part of that period, the Secretary of State considered that she had not resided here pursuant to a right of residence conferred by the Citizens Directive, and therefore did not meet the 3-year residence requirement in Regulation 5.2 of the 2006 regulations. The respondent's appeal came before the Upper Tribunal. The Upper Tribunal allowed the appeal on 2 distinct grounds. First, it held that Article 17 of the Citizens Directive, and therefore Regulation 5.2 of the 2006 regulations, did not require that the 3 years continuous residence be an exercise of rights under that directive. Actual residence was sufficient, and the respondent had been in actual residence for a sufficient time to be entitled to claim state pension credit. Secondly, the Upper Tribunal held that the decision to extend the registration scheme in 2009 was a disproportionate response to disruptions in the labour market in the United Kingdom and was therefore unlawful. On that footing, the respondent's residence here at the relevant time had not involved any breach of any applicable valid domestic law. Accordingly, even if the tribunal was wrong on its first point and the residence had to be legal in the requisite technical sense of that term in the directive, the respondent's residence here was legal in the relevant sense. The Secretary of State appealed to the Court of Appeal. Although the Court accepted the Secretary of State's arguments in relation to the first point, it agreed with the upper tribunal on the disproportionality point and therefore dismissed the appeal. The Secretary of State has now appealed to the Supreme Court. On this appeal, as well as submitting that the upper tribunal and the Court of Appeal were both right about the proportionality issue, the respondent argued that the upper tribunal was in fact correct on the first issue regarding the proper interpretation of Article 17 of the Citizens Directive, and that the Court of Appeal was wrong to come to a different conclusion. This court unanimously dismisses the appeal. It agrees with the conclusion of the upper tribunal and the Court of Appeal on the proportionality issue. The primary argument for the Secretary of State in relation to the proportionality issue was that the principle of proportionality has no application in relation to the government's decision to extend the registration scheme in 2009 under the permission granted by the Act of Accession. Although in a previous decision called Zalewska and Department for Social Development, the House of Lords had held that the principle of proportionality does apply in this context, the Secretary of State argued that that decision was mistaken and should be overruled. This court has re-examined the question, and it has come to the same conclusion as did the House of Lords. The principle of proportionality is a general principle of EU law, and it did apply in relation to the decision in 2009 to extend the registration scheme. On the footing that the principle of proportionality applies, the Secretary of State also argued that the decision to extend the registration scheme should be found to have been a proportionate measure. There was disruption in the labour market in 2009 due to the financial crisis, and having the registration scheme in place would have some effect in alleviating that disruption, even if the MAC had found that this effect was small. The Court does not accept this argument. The alleviating effect was minimal, whereas the impacts on workers and employers from having to operate the registration scheme were substantial. The negative effects of the scheme were clearly out of proportion to the minimal benefits it would produce in the period 2009 to 2011. The decision on the proportionality issue is sufficient to give the answer to the appeal. However, this court also holds, after full examination of the arguments, that the upper tribunal was correct on the issue regarding the proper interpretation of Article 17 of the Citizens Directive. Actual residence in the member state is sufficient to bring that provision into play, and this is a second reason why the respondent's claim succeeds.
The court will now adjourn.